What's up, everybody? It's Peter Tragos, the lawyer you know, and on this channel, we break down the trials and cases you care most about so you can understand how the American civil and criminal justice system works. And we try to make sure you understand what your rights are in every situation, which is why we try to walk you through the entire legal process while also answering your insightful questions along the way. And while it's not legal advice, it's always exciting. So buckle up for another episode of The Lawyer You Know. What's up, everybody, and welcome back in for another Kohberger update on this Idaho 4 case. As things continue to trickle in, people are still talking about it. There's still some theories going around, but today we actually have another legal document to discuss. We're going to talk about what it is, what it means, what the answers can potentially point us to, and where we're going in this case. We'll break all that down and more during this video. If you are still here for this Kohberger case and you want these updates to continue about the legal angles and aspects of this case, hit that like button and make sure you subscribe and hit the reminder bell on our channel so that you can continue to join us. Put your questions in the comments. Find me on Instagram and Twitter at Tragos Law right here. That's where this document was sent to me first. And then the more people that send me this document, the more likely I am to break it down for you during a video. So let's get to this document. We reviewed the state's responses to Kohberger's discovery. Now we're going to review Kohberger's responses to the state discovery. So this might be kind of hard for you to read. I am going to read it together. I just like to put it on the screen for any of you that like to read it on your own. This is the state of Idaho v. Brian Kohberger, the defendant's response to plaintiff's requests for discovery. Comes now. Brian C. Kohberger, by and through their attorney of record, Ann C. Taylor, public defender, and hereby submits the following response to plaintiff's request for discovery. So something they did not do that the state did is let everybody know we will update this discovery as we need to, as things become available. And I'm sure they will if they need to. And if things become available, then they will update their discovery. I'm sure they will. However, at this point, we have three answers. Number one, there are no books, papers, documents, photographs, or copies, or even portions thereof in the possession of the defendant at this time, which will be submitted at the time of trial. So Kohberger has no books, no documents, no photographs, nothing he plans on using as evidence at trial as we sit here today. None. That can indicate a couple things. That can indicate, he has nothing, he has no defense, or he didn't do it, so he's got nothing connecting him here. How do you prove that you didn't know somebody? How do you prove that you weren't somewhere, right? But, a big but. The defendant may use any books, papers, documents, photographs, or copies or portions thereof which have been disclosed by the state in discovery materials. So, think about what the state has disclosed or will disclose. Think about what they have. Think about where they searched. Think about what they seized and what they gathered. They've got all sorts of Brian Kohberger's possessions and electronics, photographs, videos, social media. So they already have all of this. And this is a simple way for the state to say, you gave us, thousands of documents. We're going to say we could potentially use any of those, but we don't have any individual things to present on our own. That's very common in criminal defense cases in these situations. Number two, there are no results or reports of physical or mental examinations or scientific tests which are in the possession of the defendant at this time. They put that in every answer, and that's very important. At this time, which will be submitted at the time of trial. So they haven't had anybody evaluate him and give a report just yet. That doesn't mean they won't. We have to understand what these documents actually means. That means right now, they don't have any of those test results. They haven't had them evaluated. Potentially they have, but there's no results. There's no report. There's no expert witness to disclose at this time. But we know from other cases in Idaho, you have to disclose if you're going to use some kind of mental health defense You have to disclose if you have an alibi and present the names and phone numbers and addresses and contact information for those alibi witnesses. So that still could come in the future. But as we sit here right now, nothing except for the defendant may use the results or reports of physical or mental examinations or scientific tests, which have been disclosed by the state in discovery materials. Again, they have somebody evaluate Kohberger and it says something that could help their case. I should say, if the state has somebody evaluate Kohberger and that result helps the defense's case, the defense can use that. This also, we're talking about testing computers and cell phones and social media and reports. We're seeing in other trials like Murdaugh, where they go through these electronic and digital and forensic evidence and these reports, and we're seeing how the defense is using them to their benefit, even though it's a state's witness, state's test, state report. Same thing can happen here, and the defense does not have to disclose it at this time as something they may use at trial. Now, when there's an exhibit list and a witness list, they're going to have to produce that information, of course. But as it sits right now, nothing, very common, showing no cards at this point. The defendant may also call as a witness people that were disclosed as potential witnesses by the state and any other persons who were named by the state within their other discovery materials. When available, the defendant will provide names and addresses of any additional witnesses who will be called at trial on behalf of the defendant. So once again, they give this broad scope that the state gave in their discovery responses as far as who might be a witness. Well, anybody we've listed, anybody we've interviewed, anybody whose name is mentioned anywhere in the thousands of documents we have produced as part of discovery. Well, the defense says, me too. Write me down on the back, says me too. I may call anybody too. We have no clue who anybody's going to call at this point. We're early on. Very common. So do not take anything from that. Do not run anywhere with that. This one spot here, the witnesses, is really the area where defendants are most likely to add information, add people to this list, because that is where the state might not know who can testify to the defendant's alibi, who can testify to what the defendant did or didn't do or liked or didn't like, or vegan or non-vegan, or did he have a knife or not? Did he borrow a friend's knife or not? The state and the law enforcement might not know that information. So if Kohberger and his team were likely to add something to any of these paragraphs, most likely number 3, adding witnesses. At this point, a lot of I guess they could add a mental health evaluation or report or something like that if it's done. We don't seem to think it's pointing in that direction at this point, but the books, papers, documents, the state probably has everything that's relevant at this point. The defense will look at it, scrutinize it, go through it with a fine-tooth comb and see if any of that evidence is actually good for them, and they may actually use the state stuff for number 1. Now, another thing that I don't necessarily see specifically on this list, I guess it could potentially be reports, but it's a physical or mental examination or scientific test, but they're expert reconstructionists. They will disclose that. They will disclose the report. The state will be able to respond to it. So that's something that's still coming in the future. That's more expert discovery, probably answered under a different pleading than this, or a different discovery document, I should say, than this. So that doesn't mean they're not going to use it. I'm just trying to answer a lot of the questions you guys have already had on Twitter and Instagram. This doesn't mean there's not going to be any experts. It doesn't mean they're not going to use any evidence. It doesn't mean Kohberger doesn't have any evidence. It doesn't mean he's not going to produce anything at trial. It doesn't mean he's not going to call any witnesses just because at this time he's not disclosing any of them. He's also, or through Ann Taylor, he's also not violating any rules by not disclosing things at this point. So it's not that he's got nothing. It's not that he's just totally trying to hide the ball. They're doing what they should do, playing it close to the vest, not producing things until they need to, not producing them until they actually know what they are. And it's so early in the case. This was filed on January 30th. So it's so early in the case that we still have a lot to learn. And we'll see kind of their themes, and if it's just he didn't do it or does he have an alibi, probably during that June preliminary hearing when we hear the defense team cross-examine the state's witnesses, look through the state's evidence, scrutinize the state's evidence. So a lot of that is still to come. So as things continue to trickle in on this case, feel free to send them to me. First, give me a follow on Instagram and Twitter at Tragos Law. Hit that subscribe button if you haven't already. And I will continue to break down anything I find legally relevant or that I can add value to, explaining, answer questions on. If it's random theories, I may go back and forth some with you on Twitter. Like, yeah, that's plausible. Probably not. We'd have to see evidence of it. But if there's actually a legal take and breakdown that I can give to you guys to add some value to it, like I usually say, then I will do another video like this, breaking it down and explaining all the ins and outs to you. So I appreciate you so much joining me here. I'll try to be in the chat today during this. Sometimes I can't because I've got, some appointments scattered throughout the day. I will be on tonight, 8:30 p.m. EST, potentially with a special guest who is also a big-time criminal defense lawyer, maybe joining me tonight to talk Murdaugh, talk through that trial. Make sure you're there and you hit the alarm bell and alert for that. And tell anybody else following that case to join us live at night to get their questions answered and talk through day 8 of the trial. But that's all we got for now. Thank you so much for joining me. Until next time, I'm out of here.